Good morning, members. I call the Committee of the Whole on Bill 7, the Economic Stabilization Tariff Response Act to order. We are on Clause 9. Shall Clause 9 pass?
Aye.
Recognizing the member from Richmond, Queensborough.
To Clause 9, I had a question in regards to if a procurement directive was found unconstitutional. So if a directive issued under this Act, under Section 9, later is struck down by the court or found unconstitutional, it's unclear what happens prior indemnifications granted prior to that. So will individuals still be indemnified if the directives they were following are later found to be unlawful? And if so, how does that line with legal accountability?
Recognizing the Attorney General.
So in that instance, if something was struck down as unconstitutional, or directive was, then yes, all the provisions would apply with respect to Clause 8 and 9. And interesting, I think the initial or the legal analysis is that how it would be captured is under the term intending to comply.
Recognizing the member for Kelowna Mission.
Thank you. To the relief of the Attorney General, I rise only on a point of order, and that is that while I agree with the sentiment of the sticker on the laptop from the member from Richmond Stevenson, I believe we do have rules about such things.
Members, please. Member, the rules allow that we cannot have stickers on laptops. So if you could please cover it or put the laptop away. Thank you. Recognizing the member for Richmond, Queensborough.
If a class action or a large-scale legal proceeding targets government procurement decisions taken under this Act, does Clause 9 expose the province to unlimited indemnification costs?
Recognizing the minister.
Thank you. So the same principles apply as we talked about yesterday to that scenario. So if you read Clause 8 and 9 together, the first scenario would be the immunity provision in Clause 8, and the Clause 9 is limited in scope, and we talked about this yesterday, to any cost or expenses incurred by the protected person in any legal proceedings taken. So the combination, so that wording in itself is a limiting factor on what could be what costs could be incurred through that indemnity, but you also have to remember that the two provisions acting together would mean that in such a case, as if it was a class action of the scale that the member describes, Clause 8 would kick in, and so at that point, there would be no action against that defendant, and the province would have likely taken over some sort of conduct of that matter.
Recognizing the member.
So it's a little bit unclear to me how Section 8 provides limits. I understand there's terminology in regard to bad faith that seems to be one of the limitations that Section 8 provides. Also, Section 9 also provides it. Perhaps the Attorney General can explain, does the limitation come from subsection 1 or subsection 2 in terms of that reference?
Recognize the minister.
So as we talked through yesterday, the defendant in that case would likely make an application using Clause 8 to say, there's no claim against me in this matter. And then in that instance, the province would take over in whatever fashion as it appears in that particular legal proceeding to take over. So there's a limiting factor of costs and to that defendant right from the outset when Clause 8 kicks in.
Recognizing the member.
Yesterday, we spent some time about discussing whether there was a regulatory framework or a framework guiding government procurement entities in terms of education of what legal protections there are, legal consequences there are. Something related to that, but not quite on the point. I got a question. Why is there no independent or judicial mechanism to challenge or review decisions under Clause 9 regarding who is indemnified?
Recognizing the minister.
Thank you. So in cases like this, it's very unnecessary to add in the legislation appeal process because of the fact that there's plenary jurisdiction for all courts related to matters. So it would be the court, right, that the person had access to if they disagreed with that.
Recognizing the member.
Again, we had an extensive discussion on why there wasn't enough educational guidelines, and the Attorney General's office was mentioning that whatever framework there is, that's suffice according to the Attorney General's office. But that discussion was geared towards the government procurement entities. But now my follow-up question is targeting ministries. Because we've also heard that there's been numerous ministries involved in with the Attorney General's Department in terms of this particular legislation, and we've also heard that other ministries are going to be involved after they receive the enabling statute or enabling provisions out of this legislation. So in regards to those particular other ministries, I have a question. Has the Attorney General issued any internal directives or frameworks to guide ministries in making indemnification decisions under Clause 9? We've had some discussion on government procurement entities, but now I'm steering the discussion towards ministries. Has there been any guidelines discussed with ministries how they would carry forward these directive obligations?
Recognizing the minister.
Thank you, Chair. So it's a similar process that's already in place as we talked about, as this is a very common thing for government. The provisions similar like this exist, and I think the number was 85 pieces of legislation. So the risk management branch of the Ministry of Finance is the primary body that deals with similar provisions with indemnification, along with the legal services branch. So in that structure, we work with all the ministries that may or may not have a role with this. And with that, Chair, I move that the committee rise, report progress, and ask leave to sit again.
Members have heard the question. Those in favor indicate aye. Aye. And those opposed indicate nay. Okay, motion is carried. The committee stands adjourned.